Okay, welcome everyone to our Understanding Agricultural Law webinar series, to the first webinar in this in this educational series. And the idea of this Understanding Agricultural Law educational program and webinar series is to provide information for those of you that are advising agricultural producers. So to provide information, literacy, competence, so that you all can represent those farmers and agribusinesses. And the Center for Ag and Shale Law is pleased to work with the Agricultural Business Development Center at the Pennsylvania Department of Agriculture. And we have Phil Stober with us, who is the director of the ABDC. And Phil, I'll turn the program to you just to kind of provide a little bit more information to the attendees on the ABDC.
Sure. Thanks very much, Ross, and welcome everyone to the webinar today. We're really happy you're here and really important that you're here. The ABDC, real quickly, was established as part of the 2019 Farm Bill. And specifically, what we're trying to do is help people with farm transitions, either, linking farmers to the next phase of their life, or if they want to transition from conventional farming to organic farming. We provide advice and counsel on, risk management. We're sort of the conduit, the clearinghouse, if you will, for financial assistance for farmers, loans, and some of the grants we have in Pennsylvania. And so part of our mission is also to build ag literacy and competency for everyone that touches farmers and the farming community. So legal, engineering, accounting, all the disciplines of general business. And so we're working with Penn State Law and the Center for Ag and Shale Law to help with the legal industry. And it's really important that when a farmer has a lawyer to help them through the rough spots and to help them set up their businesses and whatever it might be, that there's competency and an understanding of ag. So with Ross and Brook in the loop, we know that's going to happen, and we really appreciate you having taking the time today to sit in on this. So welcome again, and thanks for your participation, and we look forward to working with all of you going forward. Thanks.
Thanks a lot, Phil. And as I mentioned, this is the first webinar in this series. We have on the screen, you can see the next two webinars that we have. Next month, we will present on basics of leasing farmland for energy development. And then in June, we will focus on local land use regulation. Moving forward, I'm not sure that if we will do a monthly basis or if we do some more of grouping and maybe have a few hours together, but we will be providing ongoing webinars. We will have other resources as well that we will be providing on our website on these topics. Now, these first three topics are fairly broad, fairly general. As we move forward, some of the topics in this series will continue to be broad topics. Some of the topics are going to be a little bit more narrow, a little bit more focused on a very specific issue. We welcome, since we're really just launching this series today, we welcome your feedback on topics that you would find of interest as we move forward. Or if we present a general topic, like for instance today, talk about labor law generally, if there is something very specific that you would like more information on, let us know, and we can certainly respond to comments or respond to your desire for particular topics. Okay, before I get started on the substance, I want to just provide a little bit of information about the work products that the Ag Law Center at Penn State Law has. Some of you are familiar with us, some of you maybe less so, but we have a lot of resources on our website. We do external presentations as well, but the website is really the focal point where you can find all of the information. If you I have a screenshot here, you can see across the top there is an events section, and that is going to have information on any programming that we're doing, either that the center is putting together or if we're working for an external organization. We also, I have the weekly reviews here highlighted. This is a product that's prepared each week that looks at legal developments from that past week and summarizes those developments. You can see on the right, we have our social media, our Twitter, our Facebook feed, access to those. We have what we call virtual resource rooms. These are located by accessing the research by topic tab at the top. I'm showing here the Pennsylvania Right to Farm Act. So if you had needed resources, wanted to learn more, wanted to see the cases that have been decided, you could go to this virtual resource room to get more information. We also have issue trackers, which also are accessible on the research by topic tab. And these trackers, the idea is we take a particular topic, or it could be narrow or maybe broader, but we put, it's kind of create kind of a timeline, so that if you want to know what has been happening in a particular topic, you can go there and you can see all of the developments. Now, we just launched a poll here on this webinar that should have popped up a minute ago. We appreciate you answering that. It gives us a little bit more information about the audience to help us with future programs. I hope I didn't shut it down because I minimized it because it came up on my screen. So I guess someone will tell me if it is, but we appreciate you providing us with that information. We also have podcasts for those of you that prefer to get information through that source. The podcasts often take our weekly review content and provide that content just provided in a different format. We also have podcasts that go into more depth on particular topics as well. And finally, the Ag Law Center operates the Pennsylvania Agricultural Mediation Program, which is a program funded by USDA. And historically, the program has facilitated mediations involving disputes between ag producers and USDA. But a few years ago, the authorization for that program was expanded. So it now covers more than just those USDA mediations. And if you want to learn more about that, there's some information on our website, or you could check in with Jackie Schweickler, who is the coordinator for the program. Okay, so just some ground rules or housekeeping for the webinar. It's being recorded. If you have any questions, we ask that you use the Q&A feature. For Pennsylvania attorneys that wish to get CLE credits for this, there is 1 hour of substantive CLE credit that is available. There will be a link that is posted, or that just was posted in the chat, and so you can access that form in the chat, and then we will submit that so that you get your one hour of credit. In order for us to verify attendance, we use a code word, and I'll be providing that code word here later during my presentation. But you put the code word. I think the form may have it titled as attendance, or it's not labeled as code word. There's some other term, but you fill in the code word that I give you. Fill it in on that form so that we can fulfill our responsibility that we were verifying attendance. Okay, with that, I will move into the substance for today on agricultural labor law. And the presentation today, we're going to cover labor law somewhat broadly and focus on federal statutes, the kind of the major federal statutes, and and regulations that govern agricultural operations. We're going to touch at the end of the program, touch a little bit on some of the current issues, but the focus really is on understanding kind of the foundational labor laws that govern agricultural operations. I'm going to present on this first bullet point, just talk about agricultural labor somewhat generally, and then I'll talk about the Fair Labor Standards Act, the National Labor Relations Act, and the Migrant Seasonal Worker Protection Act. Then Brook Duer, a staff attorney at the center here, will talk about the H-2A program, talk about just very briefly about OSHA, FIFRA, workers' compensation. And then Brook is going to talk about some current issues as well. Okay, so just, oops, skip one too far. Okay, so agricultural labor, and just, I think it's important to understand agricultural labor when you're advising clients about agricultural labor laws. And so when we think about agricultural labor, who provides it? Certainly the farm operators are providing a lot of it, as are unpaid family workers. And being born on a dairy farm, I'm very, very familiar with that concept of unpaid family workers providing ag labor. Also, the third bullet is really where we're going to spend the time today when we talk about hired farm workers. Now, we have hired farm workers and contract labor. Obviously, there's a big distinction between a legal distinction between an employee and an independent contractor. And I think it's important that you, when you're advising your clients, that you understand exactly what their labor sources are and make sure that they are accurately characterizing any workers or any labor that they're getting. I know often people will want to characterize the employees as independent contractors, even though that they don't necessarily meet the standards that the federal government has laid out for what is required for someone to be an independent contractor. So we're going to talk about the response. Most of the presentation today, we're going to talk about the responsibilities that farms have to their employees. But again, keep in mind that, just because they're calling somebody an independent just because they're treating them as an independent contractor doesn't mean that they actually are. And I get a kick out of when people will talk about a 1099 employee, which of course is an oxymoron. But often, they may be an employee, and you need to make sure they're being treated as such if they are. This fourth bullet point, volunteers, interns, and work shares. I think this is another area where, as an attorney, you need to understand what the labor pool is, what the workforce is for this farm, because oftentimes farms will characterize people using some of these terms, and they may be doing so to avoid calling them an employee when legally they may be considered an employee. And I'll show you this website. This is from a farm in, I believe, Massachusetts, and you can see here that they're talking about their volunteer program. And you look down to this last paragraph. It says, we provide the task, you provide the labor, you work at least an hour or up to 4 hours, and at the end of that you get some vegetables. So you get, if you work 1 hour, you get $6 of vegetables. You work 4 hours, you get $25 of vegetables. So you look at this and say, are these people really volunteers, or are they part-time employees who are getting paid in vegetables? And we'll talk about some of the impact of thinking about that in terms of how that applies to your labor obligations here in just a minute. We also have an apprenticeship program, dairy grazing apprenticeship program, which is relatively new, and this is a formal apprenticeship process that's been accredited. And you have the people who want to learn about this are working on a farm. This is a formal internship, or a formal apprenticeship. and they are paid, and so when people talk about internships or all volunteers and these other types of alternative arrangements to get a labor pool, sometimes they may be treating these people as employees, sometimes they may not, and I think you have to kind of look beyond the terms that they're using to understand if they do have or what their obligations are to these workers. Okay, so looking kind of broadly at ag labor, I mean, as you look through the past decades, we've had an increasing reliance on mechanization and technology, which decreases the amount of labor that's required, but yet we have larger, more productive farms, which increases the reliance on hired labor, because now the farm operator and the unpaid family labor doesn't go quite as far. And then we have an increase in kind of the community supported agriculture type of operations that I referenced a couple slides ago, where there are members of the community that are willing to come out and provide labor kind of in a non-traditional manner. So that's kind of where we are. You look at where, how does labor fit into an ag business? And this is a chart from the National Ag Statistics Service, and you can see here, it's about the 9th line down, labor. You can see that labor accounts, and this is of course overall, all farms, large and small, regardless of the commodity that they're producing, it's 10%. And that's right up there with kind of the major expenses. You can see that there are 4 different types of expenses that are over 10%. So labor is a significant expense. Now that's gonna vary based on sector. That overall it's about 10%. If you're dealing in grain, where you're driving big combines, labor is not as much of an expense. As you move to fruits and vegetables, the so-called specialty crops, it's much higher, because these crops are much more labor intensive. So regardless, labor is a big, hired labor is a major expense, is a major issue for farms. You look at the top states, and my information is a little bit dated, so the rankings of this may have changed a little bit, but you can see that the top states are the ones that have more fruits and vegetables. Some of the states in the Great Plains that have a lot of row crops, they're not here. You can see Pennsylvania, New York are kind of right at the edge of the top 10 in states in the amount of hired agricultural labor. Okay, so here is the code word for today: business. So when you fill out your online CLE form, you can just put business in the block where it's asking for that attendance verification. Okay, so with agricultural labor laws, there really are 3 different types of laws. There are some laws where they are laws of general application, but there's an agricultural exception. And there are some laws that are general laws of general application, but they have specific sections that deal with agriculture. And then we have laws that are only have application to agriculture. Now, these are some of the laws that I mentioned at the beginning of the presentation we're going to be talking about today. Fair Labor Standards Act, OSHA, those are examples of laws of general application that have agricultural exemptions that apply. FIFRA, an example of a law that has some specific application to agriculture. Migrant Seasonal Worker Protection Act, that's an example of a statute that only has application to agriculture. Okay, the Fair Labor Standards Act. As I said, this is a law of general application, but there are some agricultural exemptions that are very important to understand. The Fair Labor Standards Act, it is addresses kind of the 3 main points that we're going to talk about are a minimum wage, overtime pay, and child labor, and it does require an employment relationship, so it does not have application to independent contractors. it provides a partial agricultural exemption. So agriculture still has to comply with some agricultural operations have to comply with some provisions of this act, but there are some exemptions, which I'll talk about here. And when you think about why do we have these exemptions? And there are some unique needs or some unique attributes of agriculture. It tends to be more seasonal, where overtime pay may be a bit more impractical in some cases. There can be the high use of labor from extended family or neighbors. There also just can be kind of some historic or policy reasons why policymakers want to provide these exemptions for agriculture, but we shouldn't take for granted that these exemptions will always be there, because we are seeing some activity at the state level to walk back some of these exemptions in labor laws. So we're going to talk about the exemptions that are in place at the federal level. There are certainly good reasons as to why these exemptions have been in place, but as with many other things, things can change. So we will talk about the exemptions to all three of these provisions that I mentioned earlier: the minimum wage, the overtime, and the child labor. Okay, so for agriculture, for minimum wage, it is a partial exemption. And for a farm to qualify for the exemption to minimum wage, there are four specific exemptions. The first of these is the 500 man days exemption, and that's the term. Man day is the term in the statute, and it means any day where you have an employee that performs agricultural labor for not less than an hour. So provides an hour or more of agricultural labor. And the standard is that 500 man days during any calendar quarter in the prior calendar year. So a calendar quarter is January, February, March, April, May, June, July, August, September, October, November, December. So you have those 4 calendar quarters in each year. And if a farm has utilized more than 500 man days of ag labor during any of those quarters in the prior year, then they are required to pay minimum wage. They no longer qualify for this exemption. So this man days, if you have this idea of 500, if you have a standard workforce that full-time workers that are working 40 hours a week, you're looking at roughly 7 full-time workers. Now, if your workers work 5 days a week or 6 days a week, that's going to make a difference. And where this becomes a little tricky in application, and where it requires perhaps a little bit of planning for the farms, is as it would apply to part-time workers. So if you have, let's say you have a strawberry farm and you have, 100 people will come out an hour a day, or 100 people will come out for 1 hour and work in your fields. Well, you just have 100 man days. If you had 10 people who came out and worked for 10 hours a day, you'd have 10 man days. So you can see that, if you're on that threshold of 500 man days, it can be important to structure it to say, okay, we want people to work 2 hours a day and not 1 hour a day. And going back to the slide that I showed you with the CSA, where they were paying their quote volunteers in vegetables, if these workers are in fact considered to be employees and not volunteers, then that farm, by structuring it and allowing people to work an hour at a time, they may be exceeding that 500 man day threshold. So if there's some uncertainty about whether a particular person working or a particular class of people working are considered are going to be considered employees or not, you might want to advise them to act in a manner that's not going to impose another obligation on them, to say, to make sure that if these people are considered to be employees, that we're not incurring this obligation to pay them minimum wage. Okay, the second exemption, or the way that a farm can qualify for a minimum wage exemption to minimum wage is to immediate family members. And by immediate family members, this is referring to kind of up and down the lineal chain. So parents, children, grandparents, stepchildren, those are all considered immediate family members. Brothers, sisters are not. Nieces, nephews, uncles are not. It's just working your way directly up and down that lineal chain, or that lineal ancestry line. Okay, another two more ways to get exemption from minimum wage is for workers that are primarily engaged in range production of livestock, as well as hand harvest laborers paid on a piece rate basis. So if you have people that are commuting daily to pick strawberries, you're employing them less than 13 weeks, then you don't have this obligation. Okay, overtime exemption. This is a complete exemption for farms, but they have to meet the definition of agriculture. And this is the definition. We're going to talk about this a little bit later. There's the so-called primary definition of agriculture is highlighted in yellow, and the secondary definition of agriculture is highlighted in green. And I'll talk about this a little bit in more detail when we talk about the National Labor Relations Act. But if you meet this definition of agriculture, there's a complete exemption for paying overtime. Okay, child labor. Generally, FLSA prohibits the use of oppressive child labor, and they define that as any employment under the age of 16 and any employment for 16 and 17-year-olds if that's in a hazardous occupation. With agriculture, we're basically pushing those ages downward, and we're saying that 16 and 17-year-olds, they can engage in hazardous occupations, and below 16, they are permitted to work. So 14 and 15-year-olds in agriculture, they're permitted to work under the FLSA as long as they're not engaged in a hazardous activity. Now, hazardous activity is very, very specifically defined, and I think it's important for you to understand that it is specifically defined. And when you look in the Code of Federal Regulations, I have here the standard for what is considered to be hazardous. And as you look, and I have the remainder of this particular section in the next couple slides, but as you look at this, you will see it is very fact specific. So you look under A1, operating a tractor over 20 power takeoff horsepower is hazardous, but that's over. So if you have a tractor with 25 PTO, that's hazardous. 20 PTO is not, which means that your 15-year-olds, they can operate a tractor that's 20 power takeoff, but they can't operate one that, or they can operate a 20 power takeoff, but they can't operate a 25 power takeoff. We move down to some of the other, just again, to highlight the specificity. Look at 4 sub 2. So your 15-year-old is not permitted to work on a farm where there's a cow with a newborn calf if the umbilical cord is present. If the umbilical cord is not present, it's not hazardous and your 15-year-old can do it. Similarly, you can see in sub 5, you have the 6-inch diameter on timber. In 6, you have the 20-foot height on a ladder. On 8 sub 2, you have You have the 2-week time period after silage has been added. So my point in highlighting this is to point out that, if you have children, if you have 15-year-olds or less working on a farm, you need to know exactly what they're doing. And the farmer needs to know exactly what activities are permitted and what activities are not permitted. Okay, as you get below those 14 and 15-year-olds, 12 and 13-year-olds are allowed to work if they have written permission from a parent, or if they're on a farm where the parent is employed. And if the children are under 12, they're allowed if they're permitted and they permitted, and all the employees are exempt from minimum wage. So you're dealing probably with the smaller operations. Okay, so that's the FLSA. Now, shifting gears to the National Labor Relations Act. This is a statute that provides workers with the ability to organize, to unionize, and as it pertains to agriculture, I mean, there is an exemption of agricultural laborers, and so this right doesn't extend to a worker if they don't fit that definition of employee. And the definition of employee does not, and I have the language quoted here, it shall not include any individual that's employed as an agricultural laborer. And that exemption is put into the or is added through the Appropriations Act, that every year Congress in the appropriations to the for the National Labor, for the application of the National Labor Relations Act, they have included language that states this, so that it keeps this essentially this exemption in place. So the impact of this is that if someone is an agricultural laborer, they cannot organize, they cannot create a union. So we have to determine, okay, is someone an agricultural laborer or not? And there was the U.S. Supreme Court addressed this issue. What was the year of this? It was in 1996 in the Holly Farms case. And the basic facts in Holly Farms are that the representation petition had been filed to create a bargaining unit for workers that were in a so-called live haul crew. And so these are workers that a poultry company would utilize to go to one of their independent growers to pick up the chickens that were grown and bring them back to the processing plant. So this live haul crew consisted of a truck driver, a forklift operator, and chicken catchers. So I think there were 9, so maybe 7 chicken catchers, a forklift operator, and a truck driver. And the issue that the court looked at is whether they were considered agricultural laborers, because if they are agricultural laborers, they can't form that bargaining unit. And so to address this, the court looked at this definition that I referred to later for the overtime exemption of agriculture, and looked at the primary agriculture, which is the first part of the statute that I think I had highlighted in yellow, which says that it includes farming in all of its branches, and kind of goes on and lists a variety of different commodities. Now, the court, based on the precedent from the Bayside case that the Supreme Court had issued about 2 decades prior to that, the issue was pretty well established that Holly Farms was not a farmer when it collected the poultry, because in Bayside, the court determined that in that typical relationship with a contract grower, it's the contract grower that is the farmer. The integrator is not a farmer. So in Holly Farms, the court looked at that primary agriculture and said, Holly Farms doesn't meet that definition. But the secondary agriculture is really where they focus, the Supreme Court focused their attention, and that states that it is considered to be agriculture, or the workers would be agricultural laborers, where there are any practices performed by a farmer, of course they're not a farmer, or on a farm as incident to or in conjunction with such farming operations. And so that's where the court focused on. Were these workers doing work that was on a farm incident to or in conjunction with the farming operation? Now, the truck driver clearly was not doing work on the farm. So that was kind of discounted because that work is done kind of coming to and from the farm. But for the forklift operators and the chicken catchers, the court determined that their work was not in conjunction with or incidental to the poultry, the independent growers' poultry raising operations, that it was incidental to the processor. And so the court determined that these workers were not agricultural laborers. They did not fall under the definition of secondary agriculture. Thus, they could unionize. Now, you contrast this with the operations at a typical hatchery, where the poultry company does own the chickens and the employees are doing the work in raising them. Now, in that case, if this same crew were to go to a similar crew were to go to pick up the chickens for the hatchery, that they would meet the definition of primary agriculture, because since Tyson or Purdue or the other integrator is doing the work of raising the chickens, they're considered farmers. So that's kind of the dichotomy that we have, where if the work is done by a farmer, if it's done on a farm as incident to with such farming operations, it meets this definition of agriculture, and the workers cannot form a bargaining unit. Okay, the last statute I want to talk about, Migrant and Seasonal Agricultural Worker Protection Act, enacted in 1983 to provide protection to migrant and seasonal workers. Migrant workers, seasonal workers are defined in relation to whether they are absent from their permanent place of residence or not. The specific entities that need to comply are agricultural employers, as well as agricultural associations. So if you have an association that is essentially providing services to individual farmers, they have a compliance obligation. And then to farm labor contractors, those people who are actually recruiting and possibly hiring and employing, transporting, providing some services that are for those migrant and seasonal workers. Okay, very quickly through the requirements. There is registration requirements for farm labor contractors, basic requirements relating to the employment about the payment of wages, not requiring goods or services to be provided, requiring that employment terms be disclosed upon recruiting, providing a written statement of earning. Housing, if it's provided, has to meet certain requirements. Vehicle safety, if it's provided, has to meet certain requirements. There are exemptions, somewhat similar. We have the 500 man days exemption. We have some family exemptions if family members are doing the contracting. If the contracting is somewhat limited, those are exemptions. And there are, as far as enforcement, criminal administrative sanctions, and there also is a private right of action. So this can be enforced not just by the government. Now, I want to talk, I guess for my final point, I want to talk about joint employment, because this is a very important concept in the Migrant Seasonal Worker Protection Act. And what joint employment does is it provides that even where the farmer is not the technical employer of the workers, they still may be held responsible for complying with the act. And so it eliminates the ability for a farm to avoid responsibility by pushing off responsibilities onto a farm labor contractor. And to determine if this farm is a joint employer, you look at the standard of economic dependence. And there are 7 factors that relate to the relationship between the farm and the workers, how much they can control them, the hiring, the firing, how long has the relationship been in place, how important are those tasks to the overall business, where are the tasks performed. So based on a totality of these factors, a farm may be considered a joint employer and then is responsible for complying with the Migrant Seasonal Worker Protection Act, even if they are not the technical employer. So with that, I'm gonna turn the floor over to Brook to talk about the remaining topics for today. So I will stop sharing my screen, Brook, and it's all yours.
Great. Okay, thanks, Ross. Good afternoon, everybody. Let me get my share screen together here. Hopefully all goes without any snafus. Okay, can you see my screen? Says Understanding Agricultural Law Educational Series, Part 2?
Yeah, Brook, there it is.
Okay.
Yep, it's there now.
Just took a little bit. Okay. All right. So I will pick up here and cover a number of different topics. And then at the end, if hopefully I don't run out of time, I'm pretty notorious for running out of time, but if I don't run out of time, then we will go to just some, this idea of what some other states have been doing, particularly on minimum wage and overtime, because, it's sort of a wave that's, coming across, or maybe it doesn't have any quite direction to the way it's coming, but it's coming in various states. And you'll see the states that have gotten involved in sort of their own version of minimum wage and overtime. Okay, so first, there we go. Okay, so first issue we're going to talk about is Immigration Reform Control Act of 1986. And that's a big way to just say we're going to talk about I-9 forms. So even in your employment, in whatever type of business you're involved, whether it's a law firm or you work for somebody else, if you have any brush with this, of course, everyone is required to do this. Has nothing specifically to do with agriculture, but there are some specifics with regard to agriculture that you should just understand how this applies. Now, during the COVID, and again, everybody's more or less familiar with the concept that there's this I-9 form, and I've just put the little heading of it here, or the the letterhead, so to speak, very recognizable form, and it's perhaps the bane of every HR department's existence. But obviously not going away, and we have the whole E-Verify system for submitting these. And that is not made mandatory yet across the board, so it can still be paper forms. And the system is quickly evolving. So one of the most important things to understand for your ag clients is that they should be very attentive to the expiration date on the form of the I-9 that you're using, because the current one expires October 31 of 2022, and there seems to always be some tweak happening. So they put these expiration dates on the form to make everybody understand. And now, I was going to say, during the COVID days, we had all kinds of changes to the I-9 process, thankfully. And they were important because, farm, HR people are generally not a full-time HR person. And, there was all kinds of things happening that were throwing everybody for a loop. And luckily, knock on wood, all of the variations on the I-9 process and what was acceptable and what wasn't acceptable that occurred because of COVID are now done. So as far as I know, I think I'm accurate in saying that every little tweak that happened to this system over the last couple of years because of COVID and remote working, et cetera, is done. So we're back to standard operating procedure with regard to I-9 compliance. And the reason the COVID affected is because they were trying to accommodate situations where employees would not be personally coming into the office, and the HR people who were filling out the I-9 did not have to personally meet with them and look at documents, et cetera, personally, and verify those documents. So things could be done essentially remotely. Okay, so we're back to standard procedure. That's the message. Now, for the I-9, it's important to remember that the employer or the farm labor contractor within 3 days of the hire needs to complete it, and it needs to be retained for 3 years or 1 year after the employment relationship is terminated. So you either have to have a less than 3-year-old one in your files for all of your existing employees, or for terminated employees, you keep them for 1 year from the date. And you got to track the expiration dates on the documents because if these documents expire that are provided to you as verification of eligibility to be employed in the United States, it's the employer or the farm labor contractor applying some of the things that Ross told you about farm labor contractors and the definition of who's a farm labor contractor, et cetera. They're responsible for tracking down their employee and getting unexpired forms to satisfy what the I-9 requires. So that's the employer's responsibility, not the employee's. So the employer has got to now keep track of all this stuff and follow up with the employee whenever any document has its expiration date. And so you're going to have dates all over the place, because lots of documents expire on different schedules. All right. There are also rehire rules that if you have the same employee who comes and goes, perhaps, and you've hired them a couple of times, there is sort of a set of rules with regard to rehiring them, and it does kind of all revolve around the 3-year threshold. So I think you can basically rely on forms complete, or rely on documents that are still good and have been supplied to you within the last 3 years. But even if the document doesn't have expiration that's longer than 3 years, you have to have the form essentially redone on a rehire. Now, this includes for H-2A employees, which we'll talk about in a minute, but that's sort of a salient point with regard to the I-9 process to understand. Now, if you want to get your ag employers a little bit of free help, or you want to help yourself understand better, Cornell University has this thing called the Agricultural Workforce Development Program, and there's their their web address over here. And I have included they have a template draft standard operating procedure for ag employers to essentially conduct the I-9 process from start to finish. And a very nice document. So I put it here over in this little box, and here's the link to it right here. I'm a big guy on trying to put links in my slides when I can. So anything you see, of course, blue and underlined is a link. So Cornell has great resources, not just on this kind of thing. They got all kinds of good resources. So this happens to be a standard operating procedure for ag employers that is custom made for your clients. So it's a nice little thing to know about. All right. ICE audits and or ICE raids and I-9 audits. I should have probably maybe worded that a little bit differently, but the bottom line is we all lived through the last couple of years where ag employers were in fact becoming a frequent target of what was called ICE raids. And the Immigration and Customs Enforcement, and that's one unit under the bigger umbrella of Homeland Security. And the good thing to just take away is that the so-called ICE raids, as we knew them in the last few years, have been stopped. by a policy document issued by the current administration, but it's pretty, they went out of their way to put it in writing and release it to the public, although it was an internal policy memo. And so at this point in time, that's the status of the ICE raid situation. It was quite a thing when they were hot, and many happened in Pennsylvania. At this point, that is a thing of the past, but of course could change. Now, the I-9 audit process is not a thing of the past, and that will continue. How that starts, and that's not an ICE raid is characterized, or that term is kind of used by saying that this is an unannounced request to enter the workplace, and a search warrant would have been required, and entry could be refused if there was no search warrant. Many employers didn't understand that when it was going on, but in any event, so the search warrant raid is one thing. The I-9 audit, totally different animal. You get a notice of investigation in writing. It's usually hand delivered, and it gives you 3 days to produce documents. So it's basically a subpoena for documents with a 3-day turnaround time. It's usually asking for all kinds of I-9s within parameters and payroll, so they could match it up against the I-9s in the file and see whether you got something that corresponds to everybody and for the appropriate times. Due to the I-9 non-discrimination provisions that essentially are contained in the Act, I-9s have to be stored completely separately from everything else, because the idea is that those making hiring decisions, and when they're making those hiring decisions, should not have access to any I-9 information. So that's something that has driven the HR world crazy. You'll get after the notice of investigation comes and documents are produced, then you'll get a notice of inspection results, and there is a whole laundry list of other types of documents that you can get. Whoop, I do that regularly. Inadvertently clicked my mouse. There's a whole bunch of other notices that you can get. And this process can go back and forth and back and forth. And so that is just something to be aware of. And of course, there are fines involved with technical violations or with violations. In the in the I-9, I'm reading too many Vonnegut books. In the I-9 process, $1,000 per violation. There is a whole penalty matrix, and there can be mitigating factors, et cetera. At 65% of all I-9 audits end up having some type of violation in them. So that's sort of a scary number. But the penalty matrix may mean that there is not a fine, or so just be aware. And then there is a long appeal process. So that's just a general idea of what that's all about. So ICE raids done, I-9 audits still going on, 72 hours, better make sure your clients are organized, and just try to walk them through it and keep them calm and proceed. I haven't heard a lot of firsthand reports or at this in recent times about I-9 audits and what kind of leniency is being exhibited. For a while there, very little leniency was being exhibited. Okay, next we will talk about, I see we're really running short on time. H-2A. Okay, the H-2A program, as you know, is the Agricultural Guest Worker Program, otherwise sometimes referred to as non-immigrant workers. And of course, all based on the same 1986 Act. There's 3 steps to the process. You get your temporary labor certification from the U.S. Department of Labor after applying. And a lot of things within that process have been cleaned up and made a little bit easier. Could be a lot more, improvements in the process, but it is what it is. You get your temporary labor certification finally, and then you submit the Form I-129, which is sort of the key to the whole thing, which is where you have to actually name the employees and the people that you are attempting to hire, or that you wish to apply to be approved to apply and gain their visas. And then the third step is the actual employees who you've connected with via phone or the internet, generally to that point, would then go to the consulate or U.S. embassy, wherever they are, and apply for the appropriate visa. And that's essentially, the big, picture in terms of the three steps. And this is all under the USCIS, the U.S. Citizenship and Immigration Service administers the whole process once that temporary labor certification is issued by the Department of Labor. There's no longer these requirements about newspaper advertising over here that the employer has to do to gain or to try to get domestic workers. That's all done now by the U.S. Department of Labor, and your role or your client's role as an employer is essentially electronically communicating with the Department of Labor. Okay.
Yeah, and
this shows you.
Since we are, since we are running short on time.
Yeah, right.
Some of your PowerPoint will be posted.
That's okay.
For the attendees, the PowerPoint will be posted. As he said, there's a lot of content there.
Yeah.
If anyone has any questions, please put those in the Q&A feature. And Brook, you will. Right. Yep, we'll move on.
Okay, let me keep going, and then I'll try to wrap. I know Ross has to leave right at 1. We have what you have to pay an H-2A worker is what's called the adverse effect wage rate. This is a map of the adverse. They are set by U.S. Department of Labor and then handed to the USDA, who then publishes them. This is the 2021 adverse effect wage rates, just to show you, what they look like around the country. There are certainly complaints about, the being too high, and that the process is too cumbersome, and there's still the residual idea that this is harming domestic workers. Of course, that's, sort of a political football at this point in time. Trends, there's been greater utilization in recent years. I got a little graph to show you on that. And there's been congressional enthusiasm for reform, that goes in fits and starts. The Farm Workforce Modernization Act sailed through the House in March of I've got the wrong date in here. It should be 2021, but it's dead at this point in the Senate Judiciary Committee. It was seemingly, when it passed, everyone was in love with it, but that's not panning out. This gives you a little bit of just a graphic presentation of the increase in usage. I think there's 300,000, or at least was the number of H-2A workers utilized in 2021, somewhere in that range. I guess a little less than that by this chart. It doesn't look like that'll reverse in any way. We're just going to be increasing. Workers' comp. Okay. No workers' comp exemptions of any kind in Pennsylvania. There are workers' comp exemptions in 16 other states, and here they are listed. OSHA. There is such a thing as a small farm exemption for OSHA, which applies to less than or equal to 10 employees. So at 11 employees, you lose the small farm exemption to OSHA. But you also lose it if you have even one employer-supplied housing unit. So it's 10 employees and no employer-supplied housing. Employees, of course, is a loaded question because immediate family uses the FLSA definition, and so as to whether they're an employee or not. So just like Ross said with the National Labor Relations Act, the OSHA exemption is essentially attached to their budget, and it basically says no funds can be used to enforce OSHA against this type of an ag operation. It's not in the OSHA statute. It's in budget. It's in recurring budget legislation. Record keeping, applies to ag if you're not exempt and can be enforced against you. There are some standards that are specific to ag for those employees that are employers that aren't exempt, and I've got them listed here. Those are actual OSHA standards that are overtly stated to apply to agricultural industries very specifically in the defined industries. There's a couple of general standards that apply if you're not exempt, and then there's the general duty clause, which some of us may have learned about in excruciating detail with the emergency temporary standard regarding COVID. Now, there's an advance notice of rulemaking that is pending right now with regard to an OSHA heat standard in indoor and outdoor workplaces. It's still at the advance notice of proposed rulemaking stage, but it's going to be a big issue, and there is no extra exemption for ag. So, this could be a real game changer. So it's something to be watching. Okay, Ross, how do you want to proceed? I have FIFRA to go through, which is the worker protection and pesticides. And then I also have, let's see what my last, and then I have the state minimum wage and OT.
Yeah, let's just go with the state. Let's just skip over FIFRA.
All right. Just know that in the slides, there is a bunch of information about protecting workers with regard to pesticide exposures that apply under federal law. Now, in terms of recently, and some may not have been that recent, but at this point, as of this month, we have 8 states that have gotten involved with setting minimum wage standards for farm workers and ag workers and overtime pay standards. And here their states are all listed, the 8 states, and exactly what they do. Some of it's real basic. Colorado, okay, you are eligible for minimum wage and OT just like every other worker in the state under Colorado law. Others have done things like applied the 500 man days FSLA standard to the minimum wage, for example. Sometimes Maryland has a very complex one with lots of ins and outs. So it can be a little different. The bottom line is when you see the lineup of states, yes, it does look like the kind of states that you'd anticipate being somewhat in this progressive vanguard, shall we say, but then maybe not others. But that's what we're dealing with. Whether this will ever come to Pennsylvania is another story entirely. And I'm sure we'll hear all about it and everyone will know. But I've never seen any bill in Pennsylvania that attempted, although it could be that that's happened and they've just died very, very quickly. So that's it. Thanks, everybody. We don't want to go too far past our allotted time.
Okay, so thanks a lot, everyone. If there are, I don't see any questions in the Q&A feature. So thank you all for attending, and we hope that that you'll join us for our program in May. Thank you very much.
Thanks, everyone. Have a great day.